And here we go. So thank you everyone for joining us today. We're really excited to have Jonathan Black of the Weston Law Group with us, who's going to answer all your questions about COVID. I know a lot of you have worked with Jonathan in the past. He is an excellent attorney on our panel. So I'm going to get this started here, and let's see, here we go. And can everyone see my screen okay? Can you see it okay, Jonathan?
I got it, yeah.
I see it.
Okay, great. Okay, so let's get started. And Jonathan, you can take it away.
All right, thank you for the introduction. My name is Jonathan Black. I am with Weston Law Group, PC. I've been an attorney in the real estate avenue for a while. My firm started off early on with evictions and moved up, and we do a lot of different things, from small things to dealing with public REITs to everything in between. So we work with a lot of brokers and agents, and we've been blessed to work with RERM and be paneled through them. So I'm glad I was invited on here to come talk to you guys about COVID-19. Now it is wrapping up, so some of this stuff is, although it was ever changing during the process of the stay-at-home orders, it's good to know kind of what's out there and what's going on, and allow you to maybe go back and look at files and how things are done, and in case we ever run into a pandemic again, it's good material. So I think that the best way to go through this is the way CAR kind of did. What CAR did is they looked at a very top level. What do we need statewide? And they came out with a list of forms, and here they are. And I think that CAR did a pretty good job doing this. Now, they also gave specific references for evictions and for stay-at-home orders and things that may affect your certain area. They gave a form on that too, which we'll look at. But I think their forms overall made pretty good sense based on what they were faced with. So I'm going to run through those now. Here's a list of them. And if you guys have questions during this talk, please let me know. I'd like to be able to answer them as they pop up. So feel free to just ask out loud. Assuming no one else is asking a question, that would be great. And we can go from there. So the first form they did was a PED form. And this form changed several times. Laura and I actually were on a call when a new one came out at one point, and it's an interesting form. But generally speaking, it's kind of a form that businesses were using across marketplaces, and it was one that I thought was helpful because it did three good things. One, it tracked who was going on the property. Two, it told everybody that was on the property. It gave some specific things for an owner or a person that had possession of property to clean commonly touched surfaces. And number three is the people coming on the property, it made them make a declaration that they weren't suffering from symptoms that would be alignable with COVID-19. So, you know, it didn't stop, but it definitely put some parameters in there to preventing the possible outbreak. So this is a good form to be using still right now, although I believe on, I want to say July 1st, I believe all this will be in, and potentially PAR will take down this form. But as of right now, I would continue using this form for showing property. The next form that I think was an important form that they came out with that might make a lot of sense is the CVA form, which was also connected to, oh geez, I'm drawing a blank. Laura, if you go to NUCC form, and I think this form was something that allowed for a transaction that was contracted during COVID-19 that hit some issues. For example, maybe you couldn't get an inspector out there fast enough. Maybe bank lending departments weren't completely back in place, and you needed an extension of time. These forms were pretty good at granting an extension of time and allowing people to continue the transaction, because the seller's agent would have a duty to tell a buyer that they have to perform or give a notice to perform if they weren't meeting deadlines. And these forms were allowing parties to come to an agreement to extend deadlines, which I think these were really good forms. We saw a lot of shakeout with lenders early on. There were some issues there with lenders, third parties that were inevitably, and I think we might see a little more of that, right? People losing their jobs inevitably create a little turmoil in the marketplace with lenders and third parties. But those have been, all those cases I had, we were able to work out an agreement on them. I think also, if you look at this form, another thing that's important to note is that it's very specific to the virus, so that if you have a seller or buyer that's having difficulty understanding why the transaction is taking a little longer than normal, this form is on point in regards to that. The next form, if you can move forward, there we go. It's a listing agreement, and I think this form was pretty good. This is the RLA form, and the reason that I like this form, and I think Carr came out with it and nailed it on the head, was because you had a lot of people who, and even now still, who weren't allowing agents to perform all their duties that they would normally do in successfully marketing and selling the property, right? So inevitably, they may not be allowing people to come in and see the house because they were afraid of COVID-19. It might not allow someone to put a sign on the property. There could be all kinds of things that create a limitation of your duty. Now, your general listing agreement gives you a fiduciary duty to your client to make all best efforts possible in the normal course of selling a property. And this agreement here allows for the limitation of those duties that were presented in COVID-19 based on your listing for your seller, based on your previous listing agreement. So this was another good form. The next form is Notice of Ability to Pay Rent, NTAP form, and I really like this form. In fact, I'm using a very similar form for a lot of my clients. We're seeing a lot of transactions that involve either tenancy or potential seller's carryback. And under those situations, it's important to note that there's an eviction moratorium. So if a tenant's not paying rent, you're not going to be able to evict them. But this form did a great thing, and it told the tenant, number one, that they had to pay rent. That was not going to be waived. And so far, it has not by anybody, but we'll see where that goes. And number two, they needed to contact the landlord and work out a payment plan, which was a good thing. And the next form was a payment plan. So if you did come to an agreement on a payment plan, this is an RPD form. And the RPD form has a way of coming to a payment agreement which parties can sign due to COVID-19, which is good because remember, there's only three ways. If you have a tenant or a potential seller that's not giving up possession, get rid of them, you can file an eviction, which isn't open to you right now because there's a moratorium in place for over 90 days at the very least at this point. Or you can come to an agreement with them. Here's some paperwork to form an agreement, or they abandon the property, right? So abandonment generally is out and the court's out. So this agreement was something that you could utilize in coming to an agreement with the tenants. And so the last form here is, well, I believe there's a few extra here, but this one is the eviction moratorium. And I think this is important because different states and municipalities, different counties, not states, we're in one state, my fault. Different counties are doing different things with evictions, and different cities are pursuing things differently. For example, the city of Albany has decided that it will be a defense to an eviction, failure to pay for 6 months after the stay-at-home orders are lifted for both commercial and residential, right? So you're seeing, and they can tweak that a little more than what's generally out there. They can tweak that generally more than what's out there by the state baseline, right? They can go up and make it higher precedence or higher thing to overcome to evict someone. So although that letter's there and the idea to work with your tenant, this is a great place to come for information as far as evictions go. And if you have someone that wants to potentially, a seller that wants to lease back, I would make sure that my buyer was aware that the eviction issues and the eviction moratorium was out there by giving them the sheet and telling them to consult a California real estate attorney to get more advice if they had questions on it, because the court systems are going to be very jammed up when this opens back up. It's going to be very tough to do an eviction. So if you have someone not leaving, it's going to create all kinds of problems in your transaction. The next document is the inability. So this was a legislation that's coming out. There's also, guys, there's also something in regards to inability to pay rent. There's also a 939 on commercial properties that's in the CHU has put forward. in regards to Assemblymember Chu has put forward in regards to commercial properties as well, potentially allowing commercial tenants out of their lease or an ability to renegotiate their lease. Now that has not passed yet, is my understanding, and commercial landlords are fighting that very vigorously because it's highly problematic for them in how they run their properties. But that's out there and it's looming. This right here, as far as one third of an ability not being able to pay rent, you're seeing different things correspond to different places. So in Alameda County, you saw Oakland say, hey, look, if they don't pay rent, it's a consumer debt. It's no longer attached to possession of property. So that means you have to go to small claims court to go get your rent money back. But just by winning in small claims court doesn't allow you to get your rent back or your possession of your property back. An eviction generally is attached to the issue of possession, is generally attached to the failure to pay rent, right? It runs with the land. And so under normal eviction scenarios, if you were to give a 3-day notice and someone wasn't to pay, you could evict them. You could proceed in winning the money that you're owed and proceed in getting possession restored to you by the court. The court now has split that off in some places. So we're seeing all kinds of issues here in regards to evictions and tenants not paying. Now, that being said, I've been checking on a lot of publicly held companies that have filed their queues, plus private funds. It looks like there's a good percentage of people paying their rents, higher than what was expected. So I don't know where they're coming out with this issue as far as 1/3. I don't know where that number is coming from because I haven't really seen it. But I think that the legislator is doing some very interesting things there that may have some constitutional issues. Impairment of contracts is one that comes to mind, and a takings violation is another thing. But we'll have to see how that plays out as this moves forward. So that's kind of an overview of COVID-19 and how it affects you and your business. First off, thank you guys for working through all this stuff. That's fantastic. And second of all, I'd like to open it up to some questions. I see something in the chat here. Let's see, what is this? Oh, it's a thank you. Well, thank you, Matthew. Is there any other questions?
I've just unmuted.
Or anything else?
I've just unmuted everybody.
Yep.
I've just unmuted everybody. So feel free to throw out a question or unmute yourself. So if you have a question, Richard.
One that we've been talking about a lot is coming around to tenants who have signed the initial PED, but then we get into escrow and they don't want to let us in to do the inspections. Is there any kind of workaround we can do with that?
No. Generally, under normal conditions, and that's a great question. Generally, under normal conditions, I believe I want to say it's 54, 46. I would get it wrong, but they're under the duty to allow potential purchasers, lenders, or tenants into the property. It's one of the reasons, enumerated reasons by California Civil Code, that a tenant has to allow access. And if they don't, you can give a notice to perform. And if they still don't, then you can file for the eviction in that regard. Right now, with what's in place, although not specifically outlined by the stay-at-home orders, you couldn't actually file on that scenario. So you couldn't give a 3-day notice and file an eviction. Now, that being said, could you at some point later potentially file an eviction on it? Maybe. And I don't know how that would play out just yet, but I would inform them that they need to make their best efforts possible to comply with their duty under the civil code. But I'd be careful on how I did that, because there's some harassment legislation that's floating out there in regards to notices and tenants in different counties and in different cities. So I'd be careful with it, but I'd potentially, if you can, if they're able to get them on the phone or meet them in person, I'd explain to them that there's a civil code in place that allows for them to open the property to prospective buyers. Great question, Richard. Tough workaround, by the way.
And we like offer cash, or is that going to be looked upon badly with COVID, and if they did end up going to court?
Well, I don't see why I wouldn't offer cash. I mean, the position I would take more or less is that they're under a duty to pay rents. If they're not keeping up with their duty to pay rents, and you have an owner that's potentially selling, hey, look, why don't we make an agreement on how you're going to pay this money back? and we'll work with you on that agreement, but you need to work with us as far as access goes, right? So I think that potentially you can kind of position it that way to get some traction here. That might make some sense, but my ultimate concern is there is no enforceability right now at this time that's available to you, right, for the next 90 days potentially. So if you can enforce it, then I think you just hit the nail on the head. Maybe it is some catch, right? Or maybe it is an agreement in regards to the rents that they owe or something else. So it's a very interesting world out there. Landlord attorneys and myself are on a long chat room together, and you should see some of the things that the attorneys are beside themselves for landlords at this point. I can safely say that. It's just mind blowing, that you can still get sued for habitability, not keeping up the property, yet they're not under any duty to pay. Like, if you're going to restrict one law, then restrict another. And they're just not willing to do that. So, I hope everybody that has property or has been put in a bad position here gets out and votes, obviously, in November. And let's get rid of some of these people that made some really bad policy decisions, I think, overall. So, not that I'm against health and safety, I'm all for it, but if you're going to say, hey, they don't have to pay rent or they can pay back later, then okay, well, then maybe the landlord shouldn't have to pay cost, right, that inevitably come from rents. Otherwise, you're driving one person in the ground for the benefit of another without any real explanation as to why. Not even explaining as to, there's no even explanation from them. So, all right, sorry, I don't want to get carried away. Next question, please, by all means.
We have Ahmed. He has a question in the box. Can you see it in the chat?
Yeah, let me go to the chat. Let's see here. It's best guess, when is the moratorium will be lifted, and what about the turnaround will be for
want to stay on so you can hear us?
That's a great question. So the moratorium right now, it looks like we have another 90 days. That's going to stay in place for evictions. And so when it is lifted, the turnaround, depending on where you are, it'll be longer than it usually was previous. I'll give you that, because there hasn't been any evictions done for months. I don't know how fast that turnaround is going to be in that regard. So let me give you kind of an example. I was on the phone with the sitting judge for Santa Clara County the other day, and I was being told that they have a stockpile of criminal cases, which will come first for jury trials, right? So they all get jury trials, they all get to come first, and there's a ton of them. Now, evictions also, if it's a residential one, a commercial one, you can change that in your lease so they don't have an entitlement to a jury trial, which I've seen hold water. But on a residential one, you can't. So if they ask for a jury trial, you might be out a long time on something like that. And I don't know, the rules were set that they're supposed to come before the judge within 3 months of filing, but that was back in the 70s without COVID. So I don't know how fast that's going to be, but I would suggest you could be looking at months. I mean, already in a lot of counties that we do eviction work in, we're waiting for months. Let's see here. So hypothetically, a residential tenant can be in place with no rent for, I would say in Alameda County, potentially Los Angeles and San Francisco, that would be correct. I don't see that in smaller counties. I think that even though they have less judges, I think the turnaround will be quicker. A lot of judges don't, I know in Contra Costa County, when Judge Austin was the presiding justice here, he did not tolerate jury trials for landlord-tenant disputes. Absolutely refused to do it. So if you have someone that's hard-nosed like that, potentially you can move things a lot faster. Kill me now. I will not kill you. You seem very intelligent. I do understand your frustration. Great comment. So I'm sorry about that. Yeah, just remember this in November. I think that's the most important thing, is let's get these people who have made bad policy decisions out.
Jonathan, Matthew has his hand up. Go ahead, Matthew. I'm going to unmute you. Oh, you're going to have to unmute yourself for some reason.
Well, I think Matthew's asking, there is no rent forgiveness. There is no. Well, as of right now, so the only city I saw try to do that was Richmond. Tried to do a 25% rent forgiveness, and they lost 2 to 5 on that vote in committee. No, there is not that I'm aware of. That being said, there's different things happening every day. So put an asterisk next to that, that could change in a heartbeat.
So basically, at the end of the day, if the person has a job and works and hopefully when these things are more in line with the typical standards and you have a judgment, you could proceed as rents are not forgiven. It's just delayed.
Well, not forgiven, just delayed. Well, yeah. So each city, potentially county, will have different policies on that. Like I was saying before, I was giving kind of an example. Albany is pretty close to Berkeley. It's right there in kind of the heart of everything, but it's not. It's a little known town down there, but they did a 6-month defense to an eviction for failure to pay in that 6-month period. So it's not a forgiveness thing. The tenant still owes it, but it's a defense to an eviction if you're not working with the tenant for that initial 6 months. Los Angeles County, I've seen them come up with different cities have come up with some different things that are a little bit squirrely. I've seen some come up with 18 months that you have to allow them to make the payments over 18 months. Now, if someone wasn't making the payments or wasn't working with their landlord, it appears that someone could file upon the moratorium being lifted based on the way that code's written, but it's tough to be positive of that and how that's going to shake out. I think there'd be more to be said about that, which could be a little bit problematic. So, I would just kind of pay attention to what's going on here. Again, people are doing some weird stuff out there. I know that they just passed, the state assembly just passed a slavery bill for reparations. I don't even know what that's about. So if they're doing things like that, I would be a little bit concerned with what they're going to do with the rents. So we should see where that opens up to. I would be concerned though, but guys, it's all specific. Generally speaking, the state has not come out and said, thank God, although I'm kind of expecting they will, that you have to forgive rents. I think what's going to happen is your city and your counties are going to come out and say, you have to work with your tenant for this amount of time before you can do a failure to pay eviction. The only one I've really seen try to push it through is Richmond, and they lost. So I would be kind of shocked if that comes out, and I would think that a lot of landlords are going to sue the city, the state, the municipality because they have a contract in place. It's being impaired by the legislative ruling or the municipality ruling. And then you have a whole nother issue, right? It's their property, and everybody, you're taking their property for use that's outside their control, right? So there's a takings provision that would allow for some kind of payment back. So just, guys, just keep your head up because there's a lot of weird stuff going on right now. And I can't really, it's really tough as an attorney to give good advice on that. Next question.
Thank you.
It's Richard again. You had talked about the PED possibly going away July 1st. Can you give a little more information about what you were talking about there?
Yeah, I think as things open up, I think the PED will go away. They might put in some kind of tracking, I would guess, probably some kind of tracking issue on properties in case there is an outbreak. We could notify people quickly. But I don't see the PED as being there, as being something that's in place permanently. Now OSHA has come out with some guidelines for you guys as far as showing property, wiping down commonly touched areas such as doorknobs, countertops, so on and so forth. So that is kind of covering something that's already in PED under one section. And then if you guys are keeping tracking of where you're showing that, some kind of tracking mechanism that will be self-imposed, I think would do something that could help you in that regard to get rid of PED. And the last one is obviously if someone has symptoms, the testing has gotten a lot faster. So I think that element of the PED form is probably going to become a moot issue. So I would say it's probably going to go away then, and that's just me kind of putting some common sense to the situation. I don't know for sure though. I mean, that'll be Carr's decision, not mine. But if other people in the industry are using a standard duty of care, I would want you guys to use the same standard, because people will point at that if there is someone that's faced with a health consequence from not using it.
All right, thank you.
No problem. Something else popped up. Let's hear. Special provisions for tenants who have pets. Are there any special provisions for tenants who have pets that are exclusion from? Jimmy, I think what you're asking is there's emotional support animals, and they're treated differently under leases because they're under the ADA Act, American with Disabilities
Yes.
Act. So really good question, Jimmy. I have a picture of a dog in my office called Couscous. It was one of the evictions we did up in somewhere up north. I can't even remember. And this guy went out and got him right before a hearing and got a
Right.
note. And inevitably we lost the hearing because it went against the ADA proposal. You know, I would be very careful in that scenario. I would inform them going in, if they didn't have a dog, that there are no pets, and put those parameters in the lease. And that if there is to be a pet, then the deposit's going to be some ungodly amount because of the property and the potential for damage. But people can work around that. I mean, I've had I was joking about this once with a flight attendant on a flight, and she showed me a picture of someone sitting with a hawk on their arm on the plane. That was an emotional support animal. So this thing's gotten way out of control, and it's a really good question, Jimmy. I don't know how to kind of nail it on the head and give you some legal logic on this one, but you know, they're out there. So I would be careful. You know, I would address the situation as, you understand that there's no pets, you clearly have a pet. Can you explain why? And get them to answer in writing. If that answer in writing to you is something other than the fact that they have a note because it's an emotional support animal, then I think you've got a good grounds for giving them a notice, right? And then if they want to pull out the fact that they got the card later, I think that's going to be a problem after you filed. And at the very least, you could ask for your filing fees and attorney fees back under the lease if it's there, because this person has violated the lease and has not informed you of the proper reasons why after the fact. So sometimes you can play it that way. But those are good factual driven scenarios that would be something that you guys could bring to me through RERM, and I can give you better answers on as you're facing. Great question. Let's see here. Matthew, is there a limit to what amount of deposit you can ask for with a pet? There are limits on deposits. With a pet, it just depends on the property. No, I don't believe there is, but you have to do it within reason. There's also another thing out there too. It's a great point, Matthew. One thing I've been telling people and haven't brought up, there is a new code on there that dictates, California legislator added again, that dictates you now have to take bonds instead of security deposits for tenants, insurance bonds. I never seen one. I'm sure that the insurance companies are scrambling to get this product out there to you, but it's out there, and it's in the California Civil Code that you have to do it. If you give me a second here, I'll take a look and see what it is, the code section, but it is there, believe it or not. Let's see here. And I just gave a talk about this the other night. I should know this thing right off the top of my head, but I do not, of course. Let's see here. It is. Sorry, I want to make sure I get this right for you guys. It is.
Matthew's asking if the landlord is required to put up a bond. It would be the tenant being required.
Tenant. No, I'm saying
right?
the tenant is the one that has to take it. That has to take the bond. I'm sorry. The tenant's the one that gives the bond to the landlord. The landlord is now by law has to take it. I know. I haven't seen these bonds, so if you guys do, let me know, but I'm looking for the civil code section on this. So give me 1 second, I'm gonna pull it up. I don't want to.
And for everybody out there, while Jonathan's looking that up, if you have specific legal questions that come up after this talk, that's why you have RERM. And basically, you talk it over the broker management team, and if, hey, you don't know the answer, fill out the quick one-sheet form, send it over to us, or give us a call here, and you know, we'll get you in contact with Jonathan so you can get these questions answered. Because, you know, knowledge is power, and we really want everybody to get all their questions answered, because that's what's going to keep you legally healthy and out of court.
Yeah, yeah, and that's a trick, right? Because all these things are changing so fast. When you're in court, it's a little bit tough to deal
Well,
with.
when we first had the lockdown, we had some law on Thursday afternoon, and all of that law was obsolete by Friday at midnight. So, okay, let's see. If a landlord comes to you and says, my tenant has not paid rent for the past 3 months, what do you recommend? I'm going to answer that one, Jonathan, because it's part of the RERM benefits. Your client, we want to make arrangements for your client to talk with an attorney to get that question answered. The attorneys for your clients are different. They don't go to Jonathan. Jonathan is your attorneys as the brokers and agents. We have a different panel of attorneys that can answer questions exactly like that. And your clients are going to get a half-an-hour telephone consultation, 10 pages of document review. And let's say they wanted to retain the attorney at a discounted rate, they could do so at a preferred rate that the attorney would quote to them. Anytime your client has a question that involves landlord-tenant, we're going to always ask you for a copy of the lease, because you would be amazed at how many different versions of leases are out there. There is really no cookie cutter. We love the CAR forms, but people sometimes come up with their own. So when your clients have that, that's just part of the benefit of working with your office. You get them those consultations to get those questions answered.
Thank you, Laura. That's exactly what I was going to say. Here it is, guys. Wait, no, that's not it. It's, shoot, I thought I just had it. I'll have to get that for you guys. God, it was right here on the tip of my tongue, and now I can't find the thing. But it was, shoot. I wish I could find this. All right, well, let me answer the next question while I'm continuing to look. Fire away.
One more
I
question.
think you answered it.
Yeah, this is Richard. If you are the landlord or the agent helping the landlord with renting the place out, and the people walk up and say, I know the animals aren't accepted, but I have a medical reason why I need it. How do you, as the agent or the landlord, how would you answer that question and probe more questions?
Right. Well, you want to be careful of discrimination, right? Because that inevitably is a big thing out there right now, and it's causing some problems in the way certain things look in the certain way you do business. But I would just say you got to submit an application like everybody else. We're going to review the applications and take the one that's the best fit. Now, if this is a person with perfect credit and everybody else doesn't have it, you might find yourself in a little bit of a position there, right? Or you may need to take this person if you want to get it out there. Guys, I'm sorry, it's AB 3260. God, that was going to drive me nuts. Found it. AB 3260 is the one in regards to the insurance bonds and everything else that you should take a look at when you get a chance and be on guard for. And that would also be part of the pet deposit there, that AB 3260. So, you know, if you need to take the best qualified person for the property, and so hopefully that person's credit isn't as good as you know, the person's credit without the animal, right? If it's
So I was understanding that you can first ask, do you have a disability? And if they say yes, then you're taking them. If they say no, it's a support animal, then you can ask if they have So how do you answer that if they say it's
You got to be
or-
careful with asking someone about their medical information, right? Because HIPAA's out there and there's privacy acts. So for the same reason that, some people don't wear masks and they say, I have a health condition. If the next question out of that store owner or restaurant owner's mouth is, what is it? Or does it affect your breathing? They can't do that. It's problematic, right? So if your questions
That's
qualify
why you
whether or
ask,
not they
do
have a
you have
disability, if there's a medical reason for the animal and they say yes, then you could ask them potentially to provide some supporting documentation for it along with their application, right? But I'd be very careful in how far you go down that path. And inevitably, a lot of times it's an anxiety-based prescription, right? So I'm not going to say those aren't valid because a lot of people do suffer from that. I'm just saying that I feel that the emotional support animal has been stretched very widely to get pets onto a premises. So, and when you know that as a landlord or someone operating a fund, it makes you a little, puts you in a little bit of a bad place as far as evaluating the situation.
Apprehensive.
Yeah, because HUD's going to come in, right? So, you want to be careful in those hearings, and everybody, they're not that expensive if you lose. I found that out through representing someone on a lipstick Wednesday night, which I had to deal with. So well, that's a good story for later. But my point is like I would just make sure that you say, okay, you need to submit all the proper documentation with your application in regards to your animal if it's for a medical reason. And leave it like that, because what you
So
don't
is it a
want
general
if someone
thing to
is
be able-
blind and it's like it's their dog, a seeing eye dog, and you deny them, that's going to be a problem, right? So you got to look at it from the position of a seeing eye dog all the way down to something that's probably an abuse of discretion and power by the doctor writing the prescription.
So is this a California law or a federal law?
Americans with Disability Act is a federal law. So remember, federal is a baseline, everything else comes up from there. The emotional support animal has really been tested in California more so than any other state. So I don't know what other states do with it. Richard, I couldn't answer that off the top of my head. So,
But if as a blanket statement, we can tell the landlords, basically, you're not going to be able to say no to an animal if they have any kind of reason, period. I mean, because you can't necessarily ask for proof.
well, no, but I think let me see if I can structure it this way. I would tell my landlord, right? If the landlord came to me and said, hey, look, I'm putting this property for rent. Potentially someone's going to come to me with an animal. I may not want to rent it to someone with an animal. How do I position that? I would tell them to say anybody who's applying to lease the premises needs to send in all the proper documentation in regards to their lease, right? So if someone called me and said, hey, to their application, excuse me, someone said, hey, I want to bring my dog, right? So I'd have a questionnaire in which they're filling out if they have an animal, and then I'd be asking for their appropriate documentation on their application along with their credit scores, right? Because I want someone that's credit worthy. And so I would have some thresholds in which I can make my selection based on a logical stance that I could defend if I denied someone with an animal who then claimed it to be an emotional support one, and me discriminating against someone with a disability. So it's your question, although I know you want one easy answer, I can't give it to you. It's a process, right? It's a process of going through the applications and making a determination. Now, if the only one applies is someone with an animal and you ask them if it's for medical reasons and they say yes, that's as far as you can go, right? So you could say or insinuate that they need to provide the documentation on that. And most people will, right? Most people get a note from their doctor in regards to the animal and they can provide that. So if you have that and they're the only person applying for the property and you deny them, they potentially have a good case, right? So it's a factual driven scenario on those lawsuits that landlords are afraid of. So you got to make sure that you're doing things that make sense. on that regard.
Jonathan, we have 2 more questions on the chat here.
So if you, by the way, there is a, I wanted to give you a resource, Disability Rights California, Richard. So if you go to disability, DISABILITY, rightsca.org, it'll give you a breakdown on the code sections and commonly asked questions that may be more specific to what you're doing. And that's very specific to California's DRC, right? So Disability Rights of California is a DRC. It's not an ABA, American ADA, American with Disabilities Act. It's not an ADA Act. It's the DRC. So I just want to make sure that you have that. Did you get that? You heard me on
I'm
that?
driving, but I'll check it.
Okay.
Richard, I'll send over an email with this information along with the recording of this meeting, so you have a record of it.
Would I please
Awesome,
set
thank
that
you.
link? Yes, I will. Here, I'm typing the message right now. Hold on a second.
Okay, so here's a question that we have. Are you able to charge a larger security deposit during the moratorium to counterbalance if the new tenant decides they do not want to pay rent when they move in day 1?
Well, there's certain parameters on how much you can charge as far as deposit goes, but right now I think you'd be okay. You'd be a month short if they didn't pay in regards to rent, and if they just rented it, I think that would be, there you guys go, disabilityrightsca.org. I think that you'd be in a better position in that regard. If it's furnished, you can charge a higher deposit, so it just depends on the property specific information. I would make sure, though, one thing I'd be checking is I would check credit and see how they plan on paying for this, right? So you could have in the application, are you employed? Are you employed locally? You could do some things like that and do some checking on that to see if they've lost their job or been laid off. That would be one of my bigger concerns. Most people do and are inclined to pay rent in my experience. It's when they lose their job, they're not, which is that kind of market right now. So I would be doing more background research than upping a deposit. There are some code sections on the book on that, and I can get that for you guys. But I would probably be doing more diligence in my application process to try to de-risk the tenancy, the incoming tenancy.
There's a form that the Apartment Association has. It's about 25 items that you can request. If you make that your standard operating procedure to have that entire form completed and all the attachments, you'll get rid of the bad tenants that way.
Yeah, no, that's perfect, Richard. I mean, I would always put the pressure on them, like, you know, as far as forms and requests for information, and see who fills out what, right? Because if you have someone diligently doing something like that, chances are they're going to be a better tenant than someone that sends you a screenshot of their bank account and a signature on a piece of paper. So yeah, I would move through that. And I think there are, California Apartment Association has, I believe, a form that you're speaking of, just like that.
One more question. This one is from Albert. Does a tenant have an obligation to mention about a support animal? So basically, if they want to rent the property, do they have to tell the landlord if they have a dog or a support animal, the hawk?
The hawk. Well, generally it depends on the paperwork in which you're having them fill out, right? So if there's a question on there whether or not they have pets, regardless if they fall under the ADA or the DRC, CDR, whatever it is. Sorry, it's on that link. I always get it backwards. They would have to tell you yes or no on that statement. So if that question was asked as part of their application, which you can do, they would have to answer it accordingly. Now, if they get one later on, that's where the problems really occur, right? So not so much in the application. No one has a pet until, a month after, oh, I just got this pet, right? So in scenarios like that, then I would have them refill out the forms. And there's certain things, you know, too, in which there are limitations, right? So in your owner's insurance policy, whether you're the owner or you're working for the owner, there can be things like no Rottweilers or certain types of pets which are deemed to be dangerous and uninsurable. So there's a whole mess of issues here in regards to pets. You know, maybe we should do talks on that, Laura, at one point. But I'll have to do a lot more research. My research on pets, so you guys know, is very factual driven. So it's a case by case scenario, right? For me, giving you some overall guidance I can do, but you know, as you get more and more detailed, it just really is driven by the facts.
And that's important, that when you have these very specific questions about, you know, the situations, that's when the brokers and agents need to go to you, Jonathan, to get those exact answers based on those exact situations. Because especially right now, there is no cookie cutter when it comes to what's happening and what's not.
Can a landlord require a tenant to obtain and pay for rent insurance in the case of disability or lost wages?
Something like an AFLAC, I'm assuming.
That's a very good question. I don't know, Claudia. Genius question. I don't know. Yeah, a landlord can enforce the fact that someone has renter insurance for a variety of different reasons. Whether or not it has riders such as disability and lost wages, I don't know. I don't know. I would assume if an insurance company can sell it, the state's not too far away from making that something enforceable by landlords because they love insurance companies. But you got me stumped.
Could you research that one, Jonathan? I'm interested in that too.
I can take a look at that. I don't know. I haven't seen a reason why they can't. I mean, it's, you know, you're contracting for your personal property. So my gut feeling is this: if you're contracting for your personal property, which you own, as long as that's a threshold that you're requiring of any applicant who's applying, then yes, you could do that. But that being said, I've never been asked that question. I've never researched it. So that's just based on being able to do things with your own property. I think that you have those rights in that scenario, right? You can say that there's no more than 2 people that can live in my property. That you can put parameters on there. So I'm sure there's a parameter that you could put on there. Yes. Great question, Claudia.
Jonathan, the reason why I was asking that is because we had this meeting with like an apartment association, and they mentioned it, and it was the first time I ever heard of it myself. And it just made me so curious about this. And I just saw like there's this one company called Rent Rescue that pays like up to 6 months of reimbursement of lost rent. And so I was like, wow, you know, maybe for those individuals who, you know, have, you know, like, I don't know. I'm just wondering if it's something that you could require. So it seems like it could be a really awesome thing for especially those investors who are kind of afraid of holding on to some of these income properties because of rent control and all of these other things that are coming up right now.
I think that's a fantastic product. If it's out there, I don't see a reason why it would be an issue with the California Constitution or any other code sections I've seen on the books in that regard. I haven't seen anything that says you can't. And when it's your own property, generally there's certain limitations there. Now, if you're doing Section 8, they have their own deal. So I don't know if that's something that you could force a Section 8 tenant, a low-income tenant, to pay for. I would assume that would be a no-go. Potentially, you could negotiate into the portion paid by housing if you're dealing with a scenario like that. So that, you know, there's a caveat to some of the things I'm saying, right? There's always a caveat in every attorney's answer, it seems like. But I think that you're more than capable of putting that in place. And I think, Claudia, that's a genius thing to do if you're doing that. If you have your property owners doing that, or you're doing that as a property owner, or however it's working out, I think that's fantastic. It really is, because, you know, Now, I would look and see if it covers epidemics, right? Because there might be, insurance companies are pretty creative in how they provide exclusions to their policy. So I might have some concerns if it would pay out under this scenario versus normal scenarios where someone lost their job or got hurt, right? That wasn't caused by a pandemic. So that might be something I'd look at. Can a landlord legally use the security deposit for past due or unpaid rents? Yes, Joan, they can. That's a great question. You can use the security deposit for past due rents. Now, you need to give notice to the tenant that you're doing that, and you need to ask the tenant to refill the security deposit, right? So although in leases it says this is not applied or shall not be used in lieu of payment of rents, that covenant is a one-way covenant towards the tenant, not the landlord. The landlord can use the security deposit for rents. Great question. Let's see here. Oh, you're welcome. I think that's it. I think I got through everything. And guys, talk to Claudia. If there's a product out there like that exists, you know, and somebody in your office is using that, I would make sure that I was using that too.
Actually,
believe,
Jonathan, I'm going to do.
Yeah.
I'm sorry.
Apartments.com or one of those, if you let them rent it for you, they have an insurance policy like that for the landlords. If the tenant loses their job during the time frame of the lease or something, but that cuts us out of the middle.
Yeah. Well, I'm going to do some research on this because I think
You don't get paid a percentage on that if you do that?
Right. If you let those that company do the leasing, we don't get paid then. But
Well,
they'll
maybe there's
guarantee
another
rent.
one. Right. Maybe there's another. Oh, you don't get paid your percentage on the guaranteed time period. Property manager would not get.
Yeah.
I see. Okay. Maybe there's another one out
okay.
there.
Well, yeah. I'm going to do some research on it and I'll share the information with everyone. And so I want to thank everyone for being with us today. I especially want to thank Jonathan. Thank you so much. We really appreciate it. And everyone remember, if you have these exact scenarios that you need legal advice on for yourself as the brokers and agents, you get to talk to Jonathan directly. You just come through the Legal Service Center first. And then if your buyers and sellers have legal questions, they get to talk to the attorneys directly and get their own consultation that you can be included on. So we want everybody to make sure that they're getting all their questions answered, dotting their I's, crossing their T's. So Jonathan, thank you again so much for spending the last hour with us. It's been really informative. And everyone, please stay healthy and safe out there.
Thank you, guys.
Thank you, everybody.
Thank you, everyone.